So, what happens when a person's civil rights seem to collide head-on with national security? We're going to dive into a case that puts that very question to the test. It's about a veteran intelligence officer whose long, distinguished career came to a grinding halt, and the reason why is at the heart of a major legal battle.
First, let's meet John Mortar. For 34 years, this guy was deep inside the U.S. intelligence community. We're talking a top-secret security clearance for his entire career. It was never pulled, never even suspended. By every measure, he was a dedicated, trusted officer.
So how does a career like that just fall apart? Well, the answer is a messy combination of a controversial screening tool, a serious medical diagnosis, and a court fight that could affect thousands of other federal employees.
To really get what this legal fight is all about, we have to go back to the beginning of John Mortar's personal story, because it's a story about incredible pressure and a test that for him was basically impossible to pass.
Okay, so it all kicks off in 2011. His wife, who also worked in intelligence, loses her job after failing a polygraph. Just 2 months later, Morter gets called in for his own. He fails, and then he fails 4 more times over the next few years, always getting tripped up on the same questions. The stress, you can imagine, it just starts to build. He's diagnosed with an adjustment disorder, then anxiety, and eventually PTSD, which his doctors tied directly to this whole polygraph ordeal. The agency, the Defense Intelligence Agency, or DIA, ends up moving him to a different job, which basically forced him into retirement. And this is where the core of the whole conflict lies. Were those 5 failed polygraphs a sign that murder was a security risk, or was something else going on? Was this a medical issue, a disability that the agency was supposed to do something about?
The medical side of this? It was pretty straightforward. One doctor after another, psychiatrists, psychologists, they all said the same thing. The high-stakes polygraph tests themselves were causing him severe anxiety and trauma. They actually put it in writing, saying he was medically unfit to keep taking them.
But the DIA, well, they didn't see it that way. The legal filings say the agency just flat out rejected all the doctor's notes. Instead of trying to find a solution, like maybe a temporary deferral, which, by the way, their own rules allow for, they just kept ordering him to take more tests even as his health was getting worse.
But here's the kicker, the real contradiction. While the polygraph unit was raising all these red flags, the DIA's own security investigators were looking into him and clearing him. A full investigation found no evidence he'd done anything wrong. A security review said his access should continue, and all the while, his top-secret clearance still active.
So, naturally, Mortar sued. He argued that the DIA was breaking the law, specifically the Rehabilitation Act, which is there to protect federal employees with disabilities. But the lower courts actually sided with the agency, and their reason came down to one very specific legal idea.
And that idea is called an essential job function. It's a bit of legal speak, but it's super important here. Basically, it means the fundamental core duties of a job. You know, the main reason you are hired. For a pilot, it's flying the plane. For a chef, it's cooking the food. It's not the side tasks, it's the whole point of the job.
And this is the ruling that changed everything for Mortar. The court said that passing a lie detector test wasn't just some administrative hurdle. No, they said it was an essential function of his job, just as important as actually analyzing intelligence. And that's a huge deal legally, because if you can't perform an essential function, an employer generally doesn't have to accommodate your disability.
So Mortar's appeal to the Supreme Court basically says, hold on, the lower courts got this totally backward. His lawyers argue that the essential function is the actual work, analyzing intelligence. The polygraph, they say, is a qualification standard. It's like a background check or a drug test. It's a hoop you have to jump through to get or keep the job. It's not the job itself. And that distinction is everything, because the law says employers have to consider accommodating a disability for a qualification standard.
So his petition to the Supreme Court boils this whole complicated mess down to 4 key questions. And these questions really get at the heart of the tension between security rules and disability rights.
First up, and this one is fundamental.
Can an agency just decide that a screening test is now a core part of the job description? Because if they can, that could create a massive loophole, letting them get around the duty to accommodate anyone with a disability that might interfere with a test.
Second, the petition looks at whether an agency has to follow its own rules.
I mean, can an agency just ignore its own rule book? The Department of Defense has a rule that says polygraphs shall be postponed if someone is medically unfit. Mortar says the DIA just blew right past that. So, are an agency's own regulations actually enforceable?
The third question really pushes on the limits of government power.
How far does the national security argument go? There's a big Supreme Court case that gives agencies a lot of leeway on who gets the security clearance. But remember, Morter's clearance was never taken away. He was just moved to another job. So can an agency use national security as a magic wand to shield any personnel decision from the courts, even if it's not about the clearance itself?
And finally, the petition asks about the process, or lack thereof. What about just talking it out? Disability law says employers have to have a good faith conversation to find a reasonable accommodation. Morter says the DIA just refused to engage. Can an agency really shut down that whole legally required process just by saying the word security?
Okay, so why should any of us care about this one man's fight with his old job? Well, because the answers to these questions could have enormous consequences for a lot of very important people.
Think about it. If the lower court's decision is the final word, it basically gives agencies a playbook for getting around disability law. Any kind of test, medical, psychological, you name it, could just be relabeled an essential function, and poof, the right to accommodation disappears. For the thousands of federal employees with security clearances who have disabilities, veterans with PTSD, for example, this could mean their jobs are suddenly on the line. Not because they can't do the work, but because they can't pass a test.
And that leaves us with this final crucial question. Nobody is arguing that national security isn't important. It is. But the laws that protect people with disabilities exist for a reason, to make sure they're judged on their abilities, not on a medical condition. This case asks the Supreme Court to find the line, and for thousands of public servants like John Mortar, their entire careers could depend on where that line is drawn.